My name is Mugambi Laibuta. I've been involved in digital rights for quite a while with some of the organizations represented here. But this session, really, what we wish to achieve is what happens before we start litigation, during litigation, and after litigation. Because you'll find that lawyers like myself, sometimes the knee-jerk reaction is going to court on a specific issue. And many of the issues that challenge digital rights come from proposed legislation, or as happened in Kenya, you find that misuse of existing legislation. So we have a distinguished panel that will really unpackage this for us. We have experiences from Kenya, Cameroon, Nigeria, and CIPESA in Uganda. But just to begin, I wish to ask Mo, I mean, just before we get into litigation, what exactly should be done? I mean, I know you're a lawyer working within the digital space in Nigeria, but what is it we can do before we litigate on digital rights?
Do I get a mic? Okay. Hi, everybody. My name is Mo. So I think that, first of all, before you start litigating on any sorts of rights anyways, you need to garner public support. That's always very instrumental, because the more people understand what's going on, the more they can support. So in order to garner public support, I think one of the things that as lawyers we forget is that, you know, the entire public are not lawyers as well. So being able to, you know, break things down in a way people understand, and it's not just legalese, because if people don't understand what this is about, how certain laws or regulations or policy affect them on a day-to-day, then they can't even, you know, be supportive of whatever you're trying to do. So in terms of, before you even get to that point of strategic litigation, obviously there has to be that point of meeting of minds between you and your objectives, and also what the public wants.
All right, let me get to Adrian. Adrian CIPESA has done quite some work within the region in Africa. So my question is, what trends as CIPESA, what trends do you see in terms of shrinking of the digital space, and what kind of initiatives do you have before, for example, in countries where there's been litigation? Are there initiatives that you've undertaken before, and what kind of results have you achieved?
Thank you very much. I'm the Adrian from CIPESA. I can tell you that I submit much better, but my voice is a bit gone. But anyway, that said, at CIPESA, with me, I have about 3 copies of some analytics, Tanzania, challenging the requirement for online bloggers and online socialists and those who publish information online to register before they can actually publish information. And one in Uganda challenging the social media tax. Of course, the decision is yet to be passed. And then the experience of the Kicternet on cyber crimes law, or computer and cyber crimes, which led to the suspension of about 26 provisions in the law. And what we've been doing, this I brought for you to take home, so you can trace the remaining copies and you take with you for reads. But one of the strategies we're taking is we have what we call catalysts for collaboration, and CIPESA has been working with MLDI and another center to put this in place, what the lawyers can look at before litigation. And the approach is that what are the best strategies for litigation? As he stated earlier, it's not all about a one-man show that I'm going to court to challenge a matter, but it's about collaboration. As our colleague from Nigeria said, that you have to garner support from the public. But for us, we take it that not only the public, but including professionals in the area, and those and also evidence gathering. So that's what we are trying to do in as far as building the capacity of litigants, lawyers in digital rights is concerned, that you see, when you want to do litigation, you do not go as an individual or as an organization. Like most of you say, you want to make a name and a mark that, yes, we are the ones who did this, but no, it doesn't work like that. You have to work with other partners, other organizations, those who are willing and unwilling. There's one way or the other in which even the unwillingness, you'll derive some benefit from it, and those who are willing, you still gather some benefit.
All right, I'll jump Daniel and go to Solomon and Wamadhai. Let me start with Wamadhai. The Bloggers Association of Kenya has been involved in different kinds of initiatives, and these are initiatives that have plugged into litigation. Maybe you could share with us. Bloggers Association and litigation; those are not two phrases that you find common. So, how did you get into the space of strategic litigation? But more specifically, what prompted you? What kind of initiatives were you involved in?
So we started the Bloggers Association in around 2010 after the realization that there wasn't an association that could speak and represent online content creators in Kenya. At the time, the government hadn't really noticed this space, and it was largely free. Fast forward to 2014, 2015, things had changed. A lot of people were being arrested. And that's the time we realized that we need to do a lot of advocacy work around the protection of human rights online, basically digital rights. And of course, being a new thing, of course, we started with advocacy. But at some point, we realized the other side, basically the state was not letting up. They were using old laws to be able to target online content creators or bloggers, if you will. And then also, they were coming up with new laws to target this constituency. And so we realized at some point we need to go to court to be able to fight some of these things. I think, of course, our famous case is so we took the government to court as far as the cyber crimes law is concerned. But we've also taken the state to court on the subversion law, and basically, as far as those two laws are concerned, in our opinion, they can be used by state and non-state actors to be able to target and restrict certain freedoms. And of course, being an association for online content creators, the biggest one is, of course, freedom of expression and freedom of the media.
All right, now let's go to Solomon from Digital Rights Initiatives Nigeria. Now, maybe you can share with us some of the matters that you've taken to court. Why did you take them to court? I mean, what really informed that decision? Because we've had different, the issue of collaboration, the issue of civic education, making and packaging these issues for the public. So maybe you can give us an example of one matter that you filed, what informed it, and what was the process like?
All right, thank you. At DRLI in Nigeria, we have a couple of cases in court, and we have matters in national court and regional court. We have our reasons for this. Now, and before I go into that, I think I need to let us know one thing that's very clear, that when I set out to launch a strategic litigation, some factors should come up in my mind. Now, the first thing are, what are my reliefs? What do I want to achieve with this litigation? The second one should be, which is the best forum? Do I go to a national court? Do I go to a regional court? I'm going to give us a very real example. There's a young man in Nigeria, is a lawyer and a local label owner. He made a tweet sometime about killings in another part of the country. After that, he was picked up by the police and taken to the nation's capital in Abuja. He was detained. After a while, released and was picked up for the second time. Now, after that, he was charged, under Section 24 of Cybercrime Act. Meanwhile, that section provides for a criminal offense with broad, vague, and unclear provisions. Now, after that, he went to court to challenge his arrest. Then the court actually granted him judgment, and he got, he got some monetary claim of about that should be about $110,000. And now the question is this: the court in the judgment specifically mentioned that the charge against him in court will continue. Now the question is this: now I actually had an encounter with his lawyer. And I said, okay, excuse me, what stopped you from challenging the reason of his arrest? Now, that would have been very strategic, because if that court had pronounced that section unconstitutional, it would not only have been a benefit for the gentleman, but would have been a national benefit to all Nigerians. Because right now, as I'm talking to you, that section is the most litigated piece of legislation in Nigeria. As of today, we have 5 cases in court. We have 2 appeal cases at the Supreme Court, 2 cases at the ECOWAS Court, and 1 at the Federal Court in Lagos. Now, so the first thing is this: for us, we need to look at the reliefs. So we actually went ahead to challenge that section, because the section says if you post anything using any computer network and somebody finds it annoying, you can be liable for 3 years in jail. You can pay a fine of 7 million naira for somebody coming up and say your post, your tweet annoyed me. So, there's another phrase, grossly offensive. So we realize that this is actually a trap that can trap anybody, even the judge. So we went to court. Though right now, like I said, we have 2 cases at the Supreme Court, and we are so strategic. One of them was actually initiated in my name, another one in the name of about 3 NGOs. So for us, we know that our courts can be friendly, may actually show some kind of, because even the judges know that that law protects them themselves. But one thing I've gotten that's clear is that as much as possible, we should understand what is the relief. Will the relief only benefit me as a person or benefit the general public?
Okay, thank you very much. Now, let's go to Dania. Dania is the president of the Cameroon Bloggers Association. You've not engaged in strategic litigation yet, but what strategies do you have? I mean, for example, in Cameroon, there was the internet shutdown at some point when there was the Francophone and Anglophone troubles. So what strategies do you have in place? I mean, we've heard Wamadhai about what the Kenyan Bloggers Association has done, but maybe you could share your experience in your strategies way forward, because we know your Bloggers Association is quite young at this point.
Thank you very much. I'm just surprised because I feel very small in this panel. While talking about registration, about digital rights, we are still struggling on starting blocks in Cameroon. So there is no strategy because we are just starting to build our association. You are talking about the internet shutdown in a few years. Yes, the event happened in 2 regions because of the Anglophone crisis with the separatists. In May 3 months, the government decided to shut down the internet in the 2 areas because a lot of people were sharing the separatist propaganda. But it was very inconvenient for the digital economy, even for all the economy itself. The government decided itself again to bring back the internet. In the absence of a structure, a major structure, which can defend the content creator and the bloggers' rights, we are still struggling, first of all, to train the bloggers themselves and to train the lawyers in Cameroon in law tech. because they are not aware of this issue. I want to take an example. The Amnesty International of Kenya told us recently that analog democracy will not be sustained. You are still in analog democracy in Cameroon. For the simple reason that we have a problem of accessibility, first of all, of internet. Not more than 15% of the population can access internet in Cameroon. So the network is concentrated in two big towns, Yaoundé, the city capital, and Douala, the economic capital. So you know you are just struggling to enter in modernity. I was very shocked when I came here to realize that in Nigeria and in Kenya, you can just use Uber. There is no Uber in Cameroon, for example. You cannot ask for a food with your smartphone in Cameroon. So that's some basic issue that we don't have in our country. So we cannot talk directly about regulations and about legacy now. It's a process.
Okay, so I mean, I think the point that it brings forward is that the difference, I mean, in the different African countries is that, for example, in Kenya we have BEC filing suits, we have bloggers being arrested, but in Cameroon still there's that struggle to get into a digital economy. I mean, in Kenya here it's not Uber, you can have five different kinds of taxi hailing apps. Now let's move forward, and this I'd like to ask. Maybe more to unpackage this, because I realize we are quite a number of lawyers here. How do we describe public interest litigation in just simple terms? What is it? When you're saying we are doing public, what's the difference between public interest litigation and just normal litigation?
I think Solomon actually, defined it quite well. It's really about what's the objective of this litigation. Sometimes when you're doing public interest litigation, it's not just about winning a case. In fact, most times it's not. It's about passing on a message, and the message is typically like, this is an issue that affects the general populace, and then we would like for this issue to actually be addressed, or at least be taken notice of. So the idea is, so once you have a situation where you are litigating not just for one individual benefits, but for the benefits of, the general population, then that's public interest litigation.
Now, something was mentioned about training, because there's a challenge in having a critical mass of individuals who understand digital rights, who can actually do public communication on them and actually litigate on this right, because not every other lawyer within the role of advocates can litigate this issue. So on the issue of training, how has CIPESA, let me start with CIPESA, then Wamadhai can give us the Kenyan example of how training has been a key factor in strategic litigation.
Thank you very much. Maybe you'll excuse me. Someone asked me and I refused to answer the question of strategic litigation. So strategic litigation is just part of public interest litigation. Only that when you go out to hunt in the forest, if you want the bigger meat or something bigger, you don't go for the antelope, you probably go for the elephant. So you target what is quite big, strategic, but it could have bearing impact to even affect the small things. And the aim is not to achieve a positive result, as I said. It may not turn out to be good, but at least certain aspects will be realized and it can be a basis for advocacy, etc. But in light of what he asks, the best strategies for training, for example, it is about doing collaborative trainings, for example, pulling together the key resource persons. Not everybody in public interest litigation or digital rights litigation is very important, especially those who have the expertise. The lawyers the digital, the bloggers. You do not have to necessarily limit yourself to only the lawyers, but bring together every key stakeholder that you know is affected and get their view on what can be done. That's one of them. And then secondly is the capacity building. Even if you brought professionals together, all of them cannot always have all the knowledge they need. So do the capacity building, use those who have been in the field of litigation for some time to make sure that they build the capacity of those individuals on how to go forward. And the capacity building targets, for example, the law evidence gathering, because it is important. Evidence gathering such that you do not aim at getting only that evidence from here and there, but it also means the friends of court, like the Huduma number case, for example, that just been decided. So many people, when you garner such support. So our main aim is to help litigation take shape by lobbying for collective effort of all experts, professionals, the academia, the civil society, through different processes that can impact on litigation, including information gathering, evidence gathering, and moving together for an advocacy strength or arm.
All right. Thank you very much. Now, Wamathai, now, Beck Blog Association has been engaged in different training initiatives. Maybe you can just share with us what these trainings have been, what have they been all about, and what has been the impact?
Around maybe 2012, 2013, we needed a lawyer to advise us on the Kenyan situation from a legal standpoint, and we were struggling to get someone who could be able to do that at the time. And we realized that it was important to be able to get as many young lawyers to this side as possible, so that they can be able to like understand this world, this digital world. And so we came up with a program for lawyers to train them on digital rights. And I'm happy to report that the current lawyer who is representing us in the cybercrimes case, we lost the case, but we're appealing, is actually a product of that training program. Her name is Masi Mutemi, and she's probably the best digital rights lawyer we have in Kenya. There's also something else, like we also realized that many online content creators didn't understand, or rather many bloggers and influencers didn't understand the laws, basically their rights, and also the laws that affect the internet. And so we also created another training program to target these people and train them, on this, like laws and regulations. This was also important, or rather, this also impacted how they write about, for instance, cases surrounding any digital rights. For instance, Huduma number, the cybercrimes law, data protection law, and I think. I'll agree with my brother from Uganda with his assertion that as far as this knowledge of this digital rights space, the legal side, I think people should not operate in a silo. So the lawyers should not have all this knowledge, and or this other side should not understand more. I think it needs to be all of us. We need to understand it, and then also collaborate. Especially for instance when you're filing cases. When we filed our case, our lawyer relied a lot on our website that archives digital rights incidences. So this is people being arrested, new policies, new laws, and and all that. And this is the kind of collaboration that I think would be helpful going forward.
Okay, thank you. Now, Solomon, I just have a question. Now, we've talked a lot about litigation, but then there's an aspect of engaging different arms of government, especially the executive and the legislature, where we have draft policy, draft legislation, and what has been your experience, what works, what does not work? Of course, we know you went to court on some of these issues, but have you had engagements with these state organs, and what has been the result of that?
Well, I think digital right litigation is actually not done effectively in isolation. You need to engage other stakeholders, the parliament, the executive. Sometimes a personal relationship with a legislator may actually win the lottery you want. And more importantly, I think for us, our romance with the media has actually paid a whole lot. Now, like Mo said, you see, if you're fighting a battle and the people are not aware, you may not be able to get much result. Let me give an example clearly. Now, currently we have 2 appeal cases at the Supreme Court in Nigeria on Section 24. Now, while that was going on, another sister NGO filed another case at the ECOWAS court. While that was going on, another NGO in Nigeria called Serap filed another one at the ECOWAS court. Now, why this? Because we realized that if all we do is to sit down, file one case in one federal court in Lagos, nobody knows about it, at the end of the day, the court may just come up and say, well, I do not agree with you that these provisions are broad. Let me give an example. There's a matter we had in court. We are challenging Section 48 of our cybercrime. That provision is very draconian and repressive. The law says that if anyone is convicted of any offense under the Act, the person shall have his international passport cancelled. Now, you'll be so surprised. Now, while we were preparing our brief, I've laid my hand on the bill that became that law. That bill says anyone who is convicted of any offense under this act shall surrender his international passport and retrieve it upon serving the jail term or paying the possible fine. Meanwhile, under that law, 95% of the offenses attract option of fine. So, but the sad thing is that the moment I'm convicted for posting a message on Facebook, and Mr. Hay or PA to the governor finds it annoying, and I'm convicted of that offense, then my international passport can be cancelled and I can be granted in Nigeria perpetually. Now, so we went to court that, well, my lord, this law is overbroad. This law cannot stand. It infringes many sections of the Constitution. Then my lord asked me, Mr. Okidara, have you committed a cybercrime? Now my question is, I said, my lord, you see, that's the point. If we are waiting to have been convicted or to have committed, it will be too late. Meanwhile, even during the hearing, my lord said it. He now turned to the AG. He said, listen, they are saying the moment they are convicted, even if the person will appeal and get a judgment obtained on appeal, their international passport is cancelled, they are granted. So what do you do? So we are saying now, when we file a case in court, we don't just sit down, we go to the media. We put it out to people. Now, some other NGOs can go to another court or go to maybe ECOWAS court. Before you know it, someday, sometime, some judge will think, I think this law is not right, and we'll be able to achieve a result.
Okay, sure. Yes.
So I just quickly wanted to add something to the two questions that have just been raised. So the first one was about training, and then the second one about collaboration. So I think, especially in the digital rights space, when we think about it, even the policymakers themselves need to be educated, right? So the reason why you have laws like that are overly broad is because sometimes the people who are even in charge of policy themselves don't really understand the implication. So the way I think about it is, if we can also be a little bit more preventative, where it's like, okay, so if you are my lawmaker, you should actually understand what this means. So that whole collaboration thing actually, in my opinion, has to start from the point where you actually even educate the policymakers themselves. Because sometimes policymakers just take this law and they're like, oh yeah, we should actually regulate social media. Okay, this is what it means, and that's it, right? So, I think that education and collaboration base really has to come from the outset.
All right, now, before we go to the questions on the floor, no, Daniel, so this question, you've had a lot about stakeholders, and it's coming out collaboration, and there are different stakeholders who've been, Mo has talked about also the lawmakers. They have to be educated, the policy makers. So now, the Blog Association in Cameroon, who have you identified as key stakeholders in this journey to protect digital rights, and why did you identify specifically these ones?
I agree with the other panelists. First of all, we need well-educated citizens. First of all, the policymakers themselves. So we are struggling to work with the politicians, first of all. Secondly, with the lawyers, because, as I said before, they are not aware on the digital right issue in my country. And the bloggers themselves, because most of them needs to have a digital education on some issues like fake news, fact-checking, and hate speech. I think, James, we started a first training session in November. I was pleased to meet James for the first time in Cameroon to come and share the experience with our bloggers. So, the policymakers, first of all, the lawyers, the civil society in general, and the bloggers themselves, we need all to be well educated. But to come to this issue, we need a lot of support in human resources, in trainers, in sessions, and we need the means to build a strong framework of digital rights in our country.
Now, I have a question that throws the spanner in the
I
works.
want to add something
Sure.
on that as far as collaboration is concerned. So our organization is about, I think, 10 years old now, and we are lucky to have learned very, very many things. And as Dania has mentioned, part of the work BAKE has done is to share experiences and to train our brothers. Of course, not just in Kenya, but also, in Africa. So we've taken our training workshops and our experiences to places like Cameroon, Zambia, Ethiopia, among others. And one of the things that I've learned about this digital rights problem that arise is like, it's like all our government and all our presidents are in the same WhatsApp group, and they exchange ideas about laws that are going to be enacted, and that's why sometimes sharing these experiences with our African brothers is amazing. For instance, in Zambia right now, they're in the middle of enacting the cybercrimes law. So sharing our experience with sharing our own experience with the cybercrimes law was important, so that they can be able to anticipate basically what's going to come, because of course they're going to get an oppressive law. I just wanted to add that.
No, just one. Everybody here, of course, understands digital rights. That's why we are here. But there has been an argument before that this issue of digital rights, it's an elite issue. For example, people who have smartphones. I think Then you've talked about in Cameroon, the digital economy. I mean, you're not there yet. You're still struggling there. Of course, Nigeria and Kenya and Uganda too. I mean, the digital economy is high. But how do we unpackage it? And I think, Adrian, how do you unpackage it for the public that this is not an elite issue, that digital rights is actually, this is something that is very fundamental? Because the argument comes, where in the Constitution does it talk about digital rights? Why is this important? How do you unpackage that? I think Mo talked about that you need to simplify this to the masses to get that support, educate them. But how do you do this?
All right, thank you very much. Digital rights is a real issue that affects all of us. For example, digital rights is not only limited to the internet. Every person, you may speak to every person that is, for example, in Kenya or Uganda, for as long as you go and register, for example, for a national identity card, you're not a subject of digital rights. For example, data protection comes into play. Every person, even those who do not have smartphones, you receive certain messages either from the ministry or from government or from somewhere, the right to know. You keep receiving information. That information is not brought and put into your phone. No. It goes through a particular platform, either through a telecommunications company, etc. If you have television, remember we're migrating from terrestrial to digital. Most of you know if you have a television, still that comes down to digital rights. So in my simple view and opinion is that the simplification of digital rights is that it's not only limited to online freedom, say internet, freedom of expression online, etc., but it encompasses and covers a diversity of issues that affect us, including social aspects like health, education. We need information every day. So it's not all about what do I have to pay for the internet, but what information do I receive and what are my rights and obligations in as far I am entitled to receive information through different platforms. So if I do not get it, my digital rights are being violated. So that is the extent and scope to which I can explain digital rights.
Now, please, for any questions or comments that you have, please log into Slido and give your comments. So I just read a few. We have 2 comments here. So there's been an offer from the Pan-African Lawyers Union, offers to work with the Lawyers Hub to set up a forum and offer support for lawyers litigating digital rights. I think this is brilliant. Paul, I think that's from Donald. So thank you. So I think that is one takeaway we can have. Then there's another. In Kenya, you say I have a comment and a question. So this one is now. So Solomon, you talked about, and this is you talked about having cases within different fora. One in the ECOWAS court, the regional court, and the national court, if I understand. So the question is, even international court becomes aware that they are dealing with a court similar to a national court, it may dismiss it. I mean, the issue of exhaustion of local remedies, whether that has been done, or whether this is ripe for this forum. So how do you coordinate these cases? And please tell us, the ECOWAS court, which are the matters you take there, and how does that have a bearing on what you have at the local level?
Well, I'm actually quite familiar with the provision of exhaustion of local remedy, which applies oftentimes to African Commission, African Court, but when the subject matter is human right, before ECOWAS court, you don't have to exhaust local remedy. That is the position. So what do we do? Now, when we go to, because we realize that oftentimes, particularly the country called Nigeria, because it thinks it has a big brother status, and oftentimes when it gets judgment from the ECOWAS court, it is embarrassed. So because of that, when we go to before a national court, and the national court judge says, well, I don't think the provision is overbroad, then we go to ECOWAS court. We know that the ECOWAS court there does not, it's not going to give us a panel of Nigerian judges. Maybe at best 1 out of the 3, judges. So at the end of the day, we want to expose ourselves to more objectivity. So then we go to such court. And one thing we do, we will not go to national court and ECOWAS court in the name of same applicants. We don't do that. Now, like I said, now one of the two appeal cases are pending at the Supreme Court. One is in my name, in my personal capacity. The second one is in the name of 3 NGOs. The one at the ECOWAS court in the name of another separate NGO. But the reality is that the same team of lawyers coordinates all these matters. And that's what we do. Then I found out another thing that happens in some other cases. Now, when you file a matter as the applicant, the same group of lawyers prepare the process for the applicant. Then the same group of lawyers prepare another set of process for amicus curiae. So at the end of the day, the judge finds himself looking at its same position of law from 2-3 different parties. And I think that works.
So now, my last question to you, Solomon, and this is in terms of litigation. And you talked about you have to think about the remedies. What are you seeing? But are there times that you just file a matter, but you really do not anticipate remedies, and why is that? And then, secondly, once a court gives you a remedy, I mean, there are orders of the court. How has it been effective? Are they effective? Are they effective remedies? Are you in a position to effect those orders?
Okay, well, the question apparently has two sides. The first side is this. The good thing with the Nigerian Constitution is Section 46 says anyone can access the court if you feel your fundamental human rights have been infringed upon, is being infringed upon, or is likely to be infringed upon. What does that mean? That means that I do not have to wait till I find myself behind the bars before I go to court. I do not have to wait till my right to freedom of expression is infringed upon because I go to court. Now, if there is a likelihood, then I can approach the court. Meaning I don't have to cite a particular infraction. And as a matter of fact, we have two cases in court against both the social media bill and the hate speech bill. What we are asking the court to do, that the court should look at the provisions of those bills, that they have a likelihood to infringe our fundamental human rights. Because we're saying the day the president puts his signature, then over 190 million Nigerians could find themselves behind the bars. So then secondly, about the implementation of the reliefs. The good thing is that most of the time when we go to court, what we ask the court for are declaratory reliefs. Now, and the good thing about declaratory reliefs is that when they are declared, you don't have to enforce them. They become effective. If the court says Section 24 of the Cybercrime Act is unconstitutional, if anyone is arrested based on that section, all you need to do is to bring that the judgment of the court before that to the court, that this law does not exist anymore. So you don't have to do more.
Okay, thank you. Now, Adrian, my last question to you. What support does CIPESA have for lawyers, organizations, institutions that want to undertake strategic litigation on digital rights?
Well, thank you very much. What I can say is we sort of have some funding. If you talk to us nicely and you see the matter is impacting, of course we can talk in that respect and see how you can get some money to support the case. I think someone from Nigeria asked me that and I responded. Then two is we are also always willing to be part of the amicus when there's need be. We come in as amicus and also support the lawyers that are pursuing the litigation. Then three is capacity building. Like we've been doing here, you can always call on us and see how we can contribute to building the capacity of the litigants. Yeah, that's it in brief.
Thank you. Daniel, last comments, 20 seconds.
Thank you. I just want to ask everyone here, every organization here, to come and help Cameroon. Helping Cameroon Bloggers Association to be the leader of planning digital rights and a strong law in my country. That's all.
Mo, any parting shot?
Yeah, I mean, for me, I'm very big on collaboration and education. So I think those two are very big pieces everybody listening on this panel should probably take away from here. So in terms of, depending on wherever you work or in what capacity you work as a lawyer or a tech person, just trying to identify organizations that are really doing work in this area and seeing how you can contribute, in your expertise to the growth. Because the thing about digital rights is it affects everybody, right? Each and every one of us can, fall victim of very overly broad legislation.
Omadai, parting shot, 20 seconds.
I'm also for collaboration, and not just on on strategic litigation. Of course, it starts with getting involved in policy. I understand in Kenya there are many groups that are working within digital rights, and we collaborate with some of them. But it would be nice if more and more people who are working in this space could collaborate. From the start, getting involved in submitting memorandum, etc., and also being enjoined in cases. Us as big, we're always ready to, to join anyone who wants to go to court around any digital rights matter. So I think, for me, more and more collaboration, and not just. From a Kenyan perspective, Africa, the world. We are willing to partner with anyone who's working in this sector, whatever, anywhere they're based.
Okay, thank you. Thank you very much from the panel. And I think what has come clear is about litigation on digital issues. Not about lawyers. It's not about going to court. There are a lot of strategies and initiatives that go around that. Like Omadai said, we developed the training curriculum for bloggers and lawyers with him, and it had an effect. CIPESA provides support in terms of material support, financial support in this litigation. I think the examples from Nigeria, the need to ensure that the public is with you when you're going to this, and also very important, which I think I took from this session, is that you also have, when you're undertaking litigation, you look at as many courts as possible. Nigeria, they have the ECOWAS court. Perhaps in East Africa, we have different. We have the East African court. South Africa, perhaps they have their. So it's all about looking at all avenues that have the greatest impact. I think the participants talked about it. The initiative that has the greatest impact. Cameroon, Daniel said they need support. I'm sure the other countries that also need support in coming up with these initiatives, and perhaps that will end in litigation. So thank you very much, panel, for your views. And I'm sure some of the participants will be in contact with you to share ideas and perhaps collaborate on these issues. Thank you very much.